We actually have our legal expert, Pete Schulte, in studio here, and something that you brought up last night was the fact that we really need to look at the totality of the things here on the table, that this was a former police officer, he had no criminal history and some military background, which could have made jurors, a little confused yesterday when it came to that sentencing decision. And there's some things to clear up this morning, as you said.
Yeah, so for the first thing that we're looking at is, when the verdict came down on Wednesday, we were shocked that he was convicted of murder but acquitted on aggravated assault. And so last night we pulled the jury charge, and that's the document that the jury is read and provided to, telling them what the law is.
What'd you find in there?
I found that there's a paragraph about the innocent party, okay? And they said that Jordan Edwards, was he an innocent party? Well, when you add that paragraph, I'm not an appellate lawyer, but I'm a trial lawyer, so I do jury charges a lot. There should have been something about law of party. So what the innocent person is that if you're walking down the street with your dog and somebody else is in a situation, they're firing at a car, and then somebody else that has nothing to do with it gets shot and killed, that's reckless, that's manslaughter. So there's no way in my opinion, for the jury to go back from reading that and going back to murder and going, well, wait a minute, that's reckless. That doesn't tell me this is manslaughter. So I think the jury, in their minds, based on the verdict, always thought this was manslaughter.
In fact, last night they were sending some notes to the judge there to clear up that confusion.
Yeah, it was just the notes that were coming out. There was some confusion back in the jury room. Now, we may never know, but what the appellate courts will do is they'll look at the jury charge and say, was the proper law given to the jury? In most cases that get overturned on appeal for a new trial, there's something with the jury charge because they're complicated. This is a unique case.
It is.
So, right, absolutely with what the outcome was. So what the appellate courts may say is, look, we think the jury thought this was manslaughter based on the recklessness of the conduct. There's no intentional or knowingly. So, but a manslaughter is a second degree. The range of punishment is 2 to 20. The jury put that sentence within 2 to 20. So what the appellate court may do, and of course I can't speak for them,
right.
but they may say this is not a murder conviction, this is a manslaughter conviction, but it's what we call harmless error because the sentence was within the guidelines for manslaughter.
It's very technical there. The fact that
very
he could be maxed out at 15 as well, and you said 7 years he could be looking at an appeal.
Yeah, so under our law, you're eligible for parole at 7.5 years. Doesn't mean you will be released. It's just when you're first eligible. He could serve all of 15 years, but we'll see. Good time behavior, how he acts in prison and so forth. But back to the sentence, he was a law enforcement officer, he was military, he didn't have any other criminal history. All that goes into sentencing, but I think the jury was focused on 2 to 20. So if you look at it from that perspective, 15 years out of a 20-year sentence is pretty high on a manslaughter. I know the family's not happy with it, but we'll see what the appellate looks.
Both sides. Thanks for joining us this morning and
Absolutely, glad
clearing
to be
up that
here.
confusion this morning. Ron, Sonia, back to you.